Your Honors, dear colleagues and guests, ladies and gentlemen, the transparency in justice is much invoked topic in our time. Number of domestic jurisdictions or justice systems globally is endeavoring to create a transparent justice system where the public and its citizens would be able to see how the justice system works, where they live, so they can hold public services to account. This is true from all over the world, from Canada, over UK, Europe, to my home country, Serbia. This goal is achieved by improvement of transparency, by publishing data and information that is accessible, meaningful, and easily understood. The concept of transparency in justice is a domestic concept in its nature, as it envisages the accountability of the public servants to local community. In the realm of the international law, the issue of transparency in justice is not only applicable, I would dare say it is even more important. The problem is that its complexity is enormous, starting from the definition of justice transparency. For purposes of international law, it must be modified and defined as the transparency of justice to public, which is affected by concrete justice system. The affected public is faced with numerous obstacles. Not only is the justice system that affects their daily lives conducted usually abroad, it is usually conducted in a foreign language. The rules of procedure and evidence are equally very different from domestic procedure to which the public is accustomed. There is little doubt that the transparency of justice in such cases is far more complicated issue and far more important goal to be achieved. Excuse me. It was our strong belief that as one of the parts of the ICTY, who by its body of jurisprudence and number of cases is undoubtedly a leader in international criminal law, our association does have a responsibility and duty to bring this issue forward at the conference. To this end, I present three of our most distinguished colleagues and friends as speakers on this subject. The first speaker was Ms. Suzana Tomanovic, who unfortunately could not make it, and Mr. Michael Karnavas gratefully accepted to give a speech on the subject of witness protection measures. Mr. Karnavas is a defense counsel, he's a former president of the ADC, defense counsel in numerous cases at ICTY, ICTR, Tribunal for Cambodia, and ICC. Mr. Karnavas will be followed by our distinguished colleague from UK, Mr. Stephen Kay, QC, defense counsel in Tadic case, Milosevic case before ICTY, Kenyatta case at the ICC at the moment, to name just a few, who will address the highly contested issue of application of Rule 70 of rules of protection, rules of procedure and evidence. At the end, Mr. Gregor Guy Smith, a defense counsel from California, another former president of ADC, and a defense counsel in some of the most significant cases at the ICT, both in trial and appeal stage, such as Haradinaj Perišić, to name just a few. He will address one of the most intriguing issues in modern culture, named the ethics of talking to media. Thank you very much. May I give the floor to Mr. Michael Karnavas.
Good morning again. One slight correction. I'm standing in for Susanna Tomanovich, so this is her prepared presentation. And I hope I don't mess it up. But it's unfortunate that she's not here because it's a true mark of a professional defense lawyer who puts the client's interests first and then her own or his own personal needs. So that's why she can't be here. Her presentation deals with the transparency of justice, the defense experience. Referring to openness and transparency, U.S. Supreme Court Justice Louis Brandeis famously noted, quote, "Sunlight is the best disinfectant." Indeed, it is, or at least it should be, at international criminal tribunals. Convictions are legitimate only when based on credible evidence presented in public trials. Witnesses are more, not less likely to be forthcoming and truthful in open proceedings when they are testifying under the watchful gaze of the public. Less room for confabulation. Yet, one pervasive conflict throughout the existence of the ICTY has been that of transparency concerning witness testimony and the production and use of certain documents in public hearings. Balancing the rights of an accused to a fair and public trial against the safety of the witnesses and victims of war crimes is an unavoidable consequence. In fact, we see this every day in our national courts when our domestic rules of evidence and procedures temper the questioning of certain witnesses or the use of certain evidence before public galleries. When considering that the truth in the court is based, for the most part, on perceptions, when, how, and for whom protection measures are used, and to the extent to which they are used, is critical to the future is a critical issue for future international criminal tribunals, in part based on the experience here at the ICTY. The ADC invited me, that is Susanna Tomanovich, to present at this legacy conference a brief overview of the witness protection measures in the ICTY procedures from the defense perspective. So, I shall be brief. So she says. Article 21 tells us that in the determination of charges against him, the accused shall be entitled to a fair and public hearing, subject to Article 22 of the statute, while Article 22 calls for the International Tribunal to provide in its rules of procedure and evidence for the protection of victims and witnesses. Such protection measures shall include, but shall not be limited to, the conduct of in-camera proceedings and the protection of victims' identity. So, the answer seems to lie in an appropriate equilibrium between Article 21 and Articles 22 of the statute on a case-by-case basis. The question we must try to answer, though, is whether ICTY trial chambers have been successful in achieving this balance. In my opinion, one which I share, not always, and certainly not consistently. Occasionally I will put myself into the picture since I'm up here anyway. Witness protection measures. I'm not going to lecture you about the legal framework of the various witness protection measures. If you are involved with or a student of the ICTY, you are well acquainted with Rule 75 dealing with the measures for protection of victims and witnesses, and Rule 79 dealing with the taking of testimony in closed sessions. All counsel for the accused have, at some point or another, challenged a prosecution's request for protective measures, and certainly we have all, as defense lawyers, challenged a trial chamber's decision to grant such measures. But we, too, have availed ourselves to the same rules and have often asked for protective measures of defense witnesses. We are all too familiar with what I consider one of the most significant rules for the defense perspective: guaranteeing safe passage. I say significant, though I must stress that this should not be understood to mean that defense witnesses are criminals and therefore need safe passage. Rather, did you want to talk to me? Okay, sorry. Rather, it is because they are testifying for the defense that they have a heightened level of anxiety and fear to appear and give evidence. Put differently, because defense witnesses will be giving evidence against the prosecution, a UN organ which, to their understanding, has extraordinary power to arrest and prosecute with few, if any, limitations, they fear retribution, that they will be arrested in The Hague if their truth, that is the witness's truth, does not coincide with the prosecutor's truth. Even when protection measures are offered on top of safe passage, the fear of some witnesses is not diminished. And in such situations, it is not unusual for the defense to be deprived of valuable witnesses in possession of exculpatory evidence, in part because of this fear. It matters not whether the fear is justified. It is a reality, which I am certain all defense will have to deal with in the course of a trial, and probably all have experienced at one point or another. It is widely accepted that many people who are victims of or witnesses to crimes find the criminal justice process stressful. Addressing this stress is essential. Much of it does result from fear, real or otherwise, that their safety is at risk if they give evidence. If there is any common factor between prosecution witnesses and defense witnesses, it is fear. This is not just at the ICTY, but at all international tribunals. For this reason, rules have been enacted and modalities implemented to assure that both prosecution and defense witnesses are afforded protective measures. I do not think that anyone among us would object to witnesses having reasonable protective measures based on a legitimate, and I underscore that, legitimate showing for protection. Also, the level of protection should be proportionate to the actual need for the sake of transparency, and it should be the least restrictive. Now, some thoughts on public trials at the ICTY. Rule 79 provides for closed sessions, the barring of the press and public from watching or listening to testimony. In virtually every case before the ICTY, the prosecution has requested protective measures for a substantial number of witnesses. Those requests have virtually all been granted by the trial chambers. It should come as no surprise that there have been trials at the ICTY. There as much as 50% of the witnesses testified under pseudonyms or with face and or voice distortion or in closed sessions. 50%. Throughout the proceedings and in the final judgment, protective measures are referred to by their pseudonyms. Trial chambers go in and out of closed sessions with considerable annoyance to the viewing public and, I'm sure, the press. It does so to shield the identity of the witnesses or to discuss matters of so-called confidential nature, some of which is merely discomforting or inconvenient, but not confidential at all. If these deviations or diversions, depending on how you view it, were merely limited to one or two witnesses per trial, it might not raise any serious questions as to whether the trials were adhered to the statutory guarantees of holding public trials. But when we often see and experience at the ICTY is nearly 50% of the hearings are closed session to the public, then we should be concerned. Also, in my experience, most important witnesses incriminating to the accused seem to testify in closed sessions. I wonder why. And is a trial really fair and open and consistent with the statute and international principles and standards as reflected in the International Covenant on Civil and Political Rights, where more than 50% of the witnesses testify under protective measures so as to ensure the witness's anonymity or even existence? Is it not difficult to envision a point at which so much of the testimony comes from secret or disguised witnesses that the trial becomes distorted, a parody? Pseudonyms and closed sessions also complicate the reading of judgments. Peppered with concealed identities of key witnesses make the judgment impossible to be scrutinized by the public. This can and often does lead to the questioning of the validity to what is represented in the judgment as facts that supposedly have been established beyond a reasonable doubt. Because here, after all, we are speaking about public perceptions. Are trials fair, really fair, and are they transparent? Protective measures for witnesses participating in proceedings must be balanced with the rights of the accused to a fair trial. There is a general principle that convictions cannot be based solely or to a decisive extent on testimony of anonymous witnesses. Also, an accused has a right of confrontation. He or she must be able to meaningfully put questions to an anonymous witness giving evidence, and do so publicly, to a large extent at least. Typically, the defense is not allowed to approach anonymous witnesses without informing the prosecutor, who then ascertains objectively, supposedly, if the witness wants to talk to the defense. This is during the investigative phase or during trial when you need to question someone in preparation for your confrontation. I personally never even dared to entertain the motion of contacting an anonymous witness in preparation of our cases. Too many obstacles for too little in return. Rule 66, dealing with disclosure, is subject to Rule 69, dealing with witness protection. Under the disclosure rules, the prosecution must disclose all prior statements in its possession for witnesses it intends to call, as well as all material submitted to the judges who confirm the indictment. Where witness protection measures have been imposed, much of this material must be restricted for distribution or even redacted to avoid undue disclosure of witness identities. These non-disclosure rules complicate the defense's pretrial preparation and in-trial preparation, especially in instances where the prosecution is asking the trial chamber to grant protective measures for large numbers of its witnesses. These complications directly impact the equality of arms that accused are entitled to enjoy. Concretely, it is questionable whether an accused, through his defense team with its limited resources, if represented by court finance counsel, because you cannot compare those of us who are under the ICTY scheme and those who are privately retained, will have sufficient time and facilities to effectively prepare his or her defense. Now, the accused's rights to examine or have examined the witnesses against him, a few words. In Tadic, and I see that there are some distinguished guests here and one speaker who was in the case. In Taditz, the first ICTY case, the trial chamber granted the prosecution's motion to keep some witness identities anonymous, not just from the public, but from the defense too, because they had this fear of retaliation, and that the trial chamber explained in its decision, which can be found in paragraph 81, that there was a strong likelihood, quote unquote, strong likelihood, that witnesses would decline to give evidence if the disclosure was conditioned to their testimony. Now, surprise, surprise, it happens to us all the time. The judgment of the European Court on Human Rights suggested that this was impermissible, but the majority of the trial chamber, with Judge Stevens dissenting, said the jurisprudence of the European Court on Human Rights only applied to ordinary criminal jurisdictions. This decision was much criticized and discussed, and no other trial chamber that we're aware of after that imposed such restrictions or attempted to impose such restrictions. Not too long ago, however, this issue cropped up again through a report on witness protection in the Balkans. In its report of June 2010, drafted by the Parliamentary Assembly of the Council of Europe. The report highlighted the plight of witnesses in the former Yugoslavia who have been murdered, threatened, and had their identities revealed by parties intent on obstructing justice. It was concluded that in the report that many witnesses are reluctant to testify, believing that they will be marked as traitors for doing so. In light of this, the Assembly criticized the ICTY's current practice of disclosing the identities of anonymous witnesses to the defense prior to trial. In cases where revealing the identities of witnesses is disproportionate to the risk of the harm to that person, the Assembly contended that such a policy is not in the interest of justice. The Assembly encouraged the ICTY to consider amending its rules to allow witness anonymity to the defense, as has been established in the European Court on Human Rights in several cases, and to consider using, quote, a special advocate functioning independently of the parties to analyze the evidence and act as an intermediary between the witness and the defense. I'm not aware, and neither am I, of the ICTY's reaction to this recommendation. I don't think I've ever seen it being discussed or implemented. But whether such measures of additional witness protection at the ICTY or MICT, the mechanism that we're into now, takes to address this criticism in the future, it's a daunting task of balancing such measures against Article 21 of the rights of an accused to examine or have examined witnesses against him. How can you possibly even begin thinking of cross-examining someone? It's a little bit like a puppet show. The defense is going to have a significant challenge in trying to influence the future of this particular decision if it is ever implemented. And then in closing, Ms. Tomanovich wanted to say a few words about the victims and witness section, as we know it as VWS. In closing, I thought I would end with perhaps a happier note, highlighting the professionalism of the victims and witness sections. As we all know, VWS was created to support and protect all witnesses, whether called by the prosecutor, the defense, or the court. This section of the registrar provides counseling, makes travel and lodging arrangements for witnesses coming to The Hague, supervises their visits, and ensures their health and safety and security. And on numerous occasions, she's had the opportunity to work with the folks in that unit. I want to express my satisfaction and gratitude for their work and for their highly professional behavior, patience, and understanding towards witnesses and towards the defense lawyers and case managers during the hectic time of the defense case. I'm saying this from my experience and based on the feedback I got from defense witnesses, which testified in two cases in which she was involved, approximately 80 witnesses. Surprisingly, however, at the seminar of Council of the ICC on the 21st and 22nd December of 2013, the special rapporteur who was there, he was commissioned to evaluate the Victims and Witness Unit at the ICC, and he presented this scathing report, which was rather interesting, both in listening to it, but the fact that it was in a very transparent fashion. And it talked about low morale, poor service, the atrocious management, and so on. One has to wonder why the good management practices of the ICTY Victims and Witness section was not taken into consideration by the ICC. This is for certain one part of the ICTY legacy which should be taken under serious consideration not only by the ICC but by other international and national tribunals. And this ends Ms. Tomanovich's presentation. Thank you.
This is going to be a challenge, I can see, and it serves me right for not printing anything. And, all right, oh, look at that. Such skill. Well, it's good to be back. And if you've been in the place where I've been for the last couple of years, you will really feel for me, because it really is another place down at the ICC. And you learn to value this institution and what it created over its 20 years and the legacy it leaves, which they deliberately sought to ignore down the road for no apparent reason, I think, other than that they thought they could do it better on blank sheets of paper rather than following the model that they have at the ICTY. And this is a legacy conference, and that's why I was very pleased and honoured to be asked to come today. And in thinking about what to say over Rule 70, I trawled around the internet as one does, and I came across a very interesting exchange in the Hamdan v. Rumsfeld case concerning the military commission and Guantanamo Bay, because it touched upon the ICTY, and the court in Hamdan was discussing the perceived lack of procedural guarantees at the ICTY and why the military commission for Guantanamo Bay could follow this as some kind of example and operate what was described in the text as being a lax standard of justice. And in many respects, it shows a complete misunderstanding and knowledge of the work of this court by the participators involved. And I'll start with Commander Swift, for it is he of counsel, who said, "Now the government again has suggested that there might be rules that could work around all this. What's important for your honours to note is that at this time and at this place there aren't any." So the judge replied, "Is that also true of what is the name of that court, the International Court of Criminal Justice that tried the Milosevic guy in Bosnia? They didn't have any rules either. They didn't even have any rules regarding punishment." Commander Swift, The court, the International Court, Your Honour, it did develop rules. They developed them, yes, sir, but at the beginning they had nothing. And in many respects, that's so of the ICTY. At the beginning there was nothing. I remember the fond times of appearing just before the Tadic case started, and with Judge Ori, in fact, we wanted to see the library at the ICTY, because we thought we might find some stuff in there that might help us in relation to the legal submissions we were going to file. And we went down there, and in fact there was one book, and it was Archbold's Criminal Pleadings circa 1968, sitting proudly on a shelf. I knew it wasn't the right edition, as it was a green one and not a red one, and in those days they changed the colours. And that was it. And we decided we'd sort of write around to colleagues around the world to try and find some ideas on submissions and set up this kind of network of exchange. It was by letter then, as none of us had email addresses, and I don't think there was even an internet, or it just started in 1996. So out of very small and humble beginnings, you've developed now this vast reservoir of justice and judicial thought, tensions on both sides, tensions from the defence, tensions from the prosecutor, and tensions from the victims. But as I said, you ain't seen nothing yet till you've been down the road to the ICC, because I'd swap my position there any day to be doing a case up here, to be frank. But there we are. Rule 70 was very much added after the original text of the rules, and was deemed a way of getting cooperation from states and other organisations who'd been in the field to provide so-called sensitive information. Originally, it didn't encompass the defence. It only encompassed the prosecution. And in fact, someone referred earlier, I mean, a lot of it didn't encompass the defence at the start, from fees, $25 an hour was the going rate, to many other aspects of catering for the defence and where we could go and what we could do. It just wasn't something that Antonio Cassese and his pals in Bassiuni really took on board in those days, as it wasn't about the defence, it was about prosecuting. And that really was the big genesis. I heard the President talk about defence guarantees. These are very minimum guarantees that you see in our rules, not reflective of a big judicial organisation. All our states are far more than those minimal guarantees. And it's taken the judges some time to develop and add to them, so that we have an extended philosophy of jurisprudence outside the original code that was provided. And Rule 70 reflects that, because later on it was realised that the defence may have sensitive information that it wanted to keep to itself, and play the same game relating to information that you couldn't use and information that the defence couldn't use or know about, and that a card could be played in a case, but you'd be powerless to deal with it. And it was later on that the same facility in a single paragraph was added to Rule 70 to allow the defence the same treatment. And I recollect in the Tadic case, the first test of Rule 70 came, and we sat down, Professor Vladimirov, Alphonse Ori and myself, looking at this text and the issue that had arisen, which concerned a satellite photograph taken by a foreign state of the Trinopolier camp near Kozarac in Bosnia, and an important third of the allegations against him. And this satellite photograph purported to show a line of buses that were taking people on a particular journey. I can't remember quite now how all that evidence tied up, but it was to reflect something that the prosecution wanted to make a point upon. But we who had been to that camp and seen it and knew about that camp in great detail, that there was actually a small fence around it, wanted to use evidence for our benefit to make further points within the trial. We were stopped from doing that. It's quite clear you couldn't do that. And we took issue over the context in which this photograph was being used, because we wanted to see the rest of the photographs. What happened further down the line? In which direction did they drive? Where did they go? And that wasn't possible. And the judges really came to this point with us through a nod and a wink. Well, you know what the rules are. We'll allow this in, but for what it's worth. And that's as far as it went. But it was an early tester, if you like, I believe, of the rules by the OTP, seeing what they could get and what kind of judgment that they could get in their favour, that they would then be able to use in the next case down the line and the next case down the line after that. And that tendency to approach issues in that way is something that all experienced defence counsel will probably recognise and understand. And I'm sure the judges do as well. I mean, this is a tester here of this rule. They've taken this situation. They want to see what kind of judgment they can develop with it. And I think that was what happened in relation to that matter in the Tardich case. The next point I want to make, very much in the grounds of exculpatory material, it is very important that evidence and rules aren't used in a way that provide an opportunity for one party to present the case it wants or it sees without the wider picture of that evidence or information being clearly understood. And I wonder how often this is really understood and recognised, that the withholding of surrounding information and confidential, under the guise of confidentiality, may in fact be used by a so-called party supporting usually the prosecution to make a point that it wants. And I'm very, very nervous about the selectiveness, the selective nature by which evidence is used in that way, and the restriction, if you like, on those who are supposed to be seeking the truth being able to say, right, you've given us this, we want to see what else you've got and see where this takes us and where this information is. I'm very uneasy about third parties being able to put information in a way that is cloaked and obscured from the wider context, as we all know that subversions of the truth are very, very possible by parties who want to influence the outcome of a case. Turning now, because just to deal with the final issue, and it just might be of interest, in the Milosevic case, I've been asked to refer to that today. I remember the Rule 70 issues concerning General Wesley Clark. It was before Lord Bonamy joined us in the trial, and it was at the stage of the prosecution case. And I have never seen such a circus in my life over that man. He came along under an enormous cloak of secrecy, this, that, and the other, and I couldn't read this, I couldn't read that, and I had a sort of half-page summary, and Judge May was banging this in, and so we were obstructing, and we wanted to raise the issue, and it was not a satisfactorily handled matter, in my view. And the evidence had to be reviewed by people in the Pentagon before it could be allowed out, and transcript. It was Miras Topuskovich was on the case as well at that time, nodding her head. We were so uneasy about what was going on. And in my mind, the prosecution were jumping to the tune of another party, the US, and it was just so apparent. And I think we would have had a different outcome, actually, with Lord Bonamy there. I think you brought in a freshness of vision that was needed, because it wasn't healthy. What happened was, I actually took exception with one part of his evidence. I just didn't trust it. I didn't think it was right at all, what he was claiming. He went out, gave a press conference outside the ICTY, having been cloaked in secrecy, and was standing as a presidential candidate. And that summed up the whole bizarre circus of shenanigans, in my view. And I think a more robust approach by the prosecution in relation to matters like that, instead of kowtowing to information providers who may bankroll this, that, or the other. But I'm sorry, justice should be kept apart from politics. And Rule 70 is a way that the outside politics can influence the outcome of cases and trials. So it has to be watched very, very carefully, in my view. Thank you very much.
I think before anybody decides to make a presentation, they run through a variety of different introductions or avenues that they will take in order to figure out how best to either amuse the audience, shock the audience, interest the audience, offend the audience. Thank you. Or have the audience begin to engage in thinking. So I came up, of course, with a whole bunch of different approaches to this, and I don't know which one of those approaches ultimately is the wisest, nor do I know which one of those approaches I will touch you with, collectively or individually. But let me start by saying the topic of ethics in the media is far-reaching. And I realized when I was invited to speak about this that today, unlike yesterday, whenever any of us stand in a public forum, we have an immediate relationship with the media. As a matter of fact, for purposes of this conference today, there was an invitation for people to Twitter, something that I do not do and I do not understand. But I know that it means that there's going to be, or the possibility there's a rapid that there's a rapid ability for the media to become involved in the conversation at hand. Lawyers, as far...
I'm so sorry. Here we go.
Lawyers, as far as I'm concerned... Lawyers, as far as I'm concerned, are members of a truly noble profession. And we conduct ourselves with dignity. We conduct ourselves with integrity, and we are concerned with the work that we do and the business that we are involved in. And one of the parts of that, and an important part of that, is raising issues not only in the courtroom, but outside in the marketplace of ideas. And in the marketplace of ideas, the standards of ethical behavior, and I'm not at this point going to speak at an abstract level, but the standards of ethical behavior are in marked contrast depending on what kind of work you do. If one is a judge, whether they are writing privately or not, there seems to be one standard. If one is a prosecutor, there seems to be another standard. But if one is a defense attorney, and if one is a defense attorney who has done work at the ICTY, there is a very clear standard, and it is a troublesome one. And that standard is that we have a positive obligation to protect the reputation of the tribunal. That particular holding came out of a disciplinary opinion concerning one of our colleagues who made the following statement in an interview. The main aim has been achieved. Serbia has been demonized. No attribution was made to an institution. No attribution was made to an individual. And for this, it was found that he was in violation of Article 3 of our Code of Conduct, which is, counsel shall take all necessary steps to ensure that their actions do not bring proceedings before the tribunal into disrepute. You can each and every one of you think about whether or not, in fact, that statement did or did not bring the tribunal, the reputation of the tribunal, into disrepute. I'd like to contrast that with another statement that was made publicly a while ago. And for brevity's sake, I promise you, I've taken out some of the language, but I have not changed the meaning at all. This was a question-answer session. Question: isn't it true that several witnesses against the accused have been murdered? Answer: the witnesses in this trial are walking away from me. Question: but isn't the tribunal itself to blame for this? Didn't the tribunal set the accused free until the start of the trial? Answer: the judges of the tribunal made this decision. I very strongly agreed with it. It could get worse, namely, if the accused is acquitted because of lack of witness testimony. That was a question. Answer: I hope not. He's guilty. Through and through, I have the evidence. Now, if you take that statement and you think about whether or not that statement might bring the tribunal into disrepute because the judges have made a decision concerning somebody that this individual believes is involved in murder, there should be some kind of sanction, some kind of concern, perhaps an investigation. The author of the statement was Carla Del Ponte. In an interview she had in 2007 concerning a pending case at the tribunal. There are no rules that would concern this kind of a statement made for the prosecutor. You may be aware of or not aware of a case in Cambodia. In that case, counsel sought to intervene and was allowed to intervene in the first instance in some of the judicial proceedings concerning a matter of great interest to their client. After a period of time, counsel was foreclosed from filing motions, from making submissions in a case in which they clearly had an interest. So a choice was made, and one may criticize or not criticize. And I'm being very careful now about the language I use because I'm want to make sure that if I do criticize anyone, I haven't violated my ethical duties. Council made a determination. The appropriate thing to do would be to get those filings into the public and make not only the public, but also the court aware of the legal arguments that were being made. So they were posted on a website. They were picked up by the media. They were picked up by the court. And the court went after counsel, saying that he'd engaged in unethical behavior, and he was referred to his local bar. His local bar did not feel that he had done anything wrong. The tribunal that he was appearing in front of took the position that he had engaged in behavior that brought disrepute to the tribunal, among other things. Now, part of this may be a difference of attitude in terms of what the function of defense counsel is. But I don't believe that I have seen yet anyone in any international case, at least the defense, engage in irresponsible conversation with regard to the criticism of the tribunal at all. And with regard to the behavior of the prosecutor, again, I don't think that I have seen any defense counsel engage in behavior that would give occasion or give rise to any kind of discipline. But that is the state of affairs right now, and it is a serious state of affairs. And the reason it's a serious state of affairs is because to the extent that, as Stephen said, that place down the road has not paid much attention to what has happened at the ICTY. To the extent they have paid attention to anything, they have paid attention to the notion that it is appropriate to muzzle counsel when speaking in public concerning matters of concern to all of us. In the absence of criticism, honestly held criticism, of honest opinion, we run a very, very grave danger. And that's the danger that we'll be silenced. And the critical thinking that exists with regard to the law, that allows for the development of the law, will evaporate and disappear. So I would urge all of you to think carefully about what you say when you speak in public, but don't lose either heart or courage in maintaining your convictions and criticizing and questioning the state of the law, the state of the tribunals, the state of the prosecutions, and the state of human existence. I thank you.
We will take the questions now. Anybody? Yes. Yes, Your Honor. Please.
Can I just say something and pick up on what Mr. Kay said? You don't need to rely on his complimentary words about me to get the whole story on General Wesley Clark. You should look at the proceedings in Milutinovich and see the circumstances in which he came not to give evidence in that case at all.
Yeah, it was. We had Milosevic running his case, and this was a big issue over the conflict over Kosovo, and he was called, he was put up there, and simply no questions could be asked, and I really do wonder what the judges thought they were doing permitting that, because it was almost like they wanted to the prosecution were trying to set up a conflict with Milosevic. And that shouldn't be going on in that way. It was a strategic thing. It was one afternoon in the court for an hour and a half, said what they wanted him to say, but the defense couldn't touch a single point. And there was even a heavily challenged statement he made to do with Srebrenica, and it deserved cross-examination. Milosevic's time ran out. I started cross-examine on it, and it was all closed down, shut, bang, out, and he goes off to do his press conference. It really was unsatisfactory, and perhaps now it wouldn't happen again, but people may have learned from lessons.
Thank you, Stephen. I believe, yeah.
I do not consider this audience participation just in a way to put questions. I would like to add something. I don't have any questions to my colleagues, but since Suzana Tomanovic opened with her very interesting speech, opened the door for some additional submission, for sake of young colleagues that are going to follow us, I would like to add something in regard witness protection measures. There are many colleagues present here who remember that witnesses were not protected just with the pseudonym, voice, and face distortion and closed sessions. In a way, the OTP took, this kind of justice and transparent justice in their hands, disclosing to the defense redacted versions of the statements. No names, no any other relevant data for the witness. You got, for example, 15 pages long statement, and more than half of that statement was black, no details. If we have in mind appeals chamber decision in Mrkšić case that the witnesses are not property of any party, that means that we have the right to have access even to the prosecution witnesses. If we would like to interview them, we are entitled to do so. But having the statements, and let's say in the pretrial brief, there is just pseudonym, we do not know who the witness is and how to approach to that witness. And we had to fight with the prosecution, addressing all the time the trial chamber, to give time limit to the prosecution to disclose details to the defense. I think with that, this basic rule, fairness of the trial, was violated because we had no that access to the data and to the witnesses. Thank you.
Thank you, Mayor.
I actually would care to comment, because you're absolutely right, Mayor. And you may recall that a number of years ago, the ADC proposed to the Rules Committee a specific rule dealing with disclosure cutoff deadlines, which, as I recall, were really quite generous, meaning that from the time that they got the information, I think they had at least a year from the receipt of information then to give it to the defense if it was information they had for that period of time. That was unfortunately rejected by the Rules Committee, but it was something that we did actually try to do.
My only supplement is that early on, you might recall when the rules before that required you to engage in this reciprocal discovery, and some didn't quite understand it. They thought that whatever they gathered in the field, the defense that is, they would have to turn over to the prosecution, which was not the case. You would only have to turn over what you actually were going to use. And back then, the prosecution supposedly had to turn over the exculpatory evidence. But you had one American prosecutor, very, very experienced prosecutor. Now he's a investigative judge. sort of in the French system, where he wrote an article where he was saying that he, as a prosecutor in these cases, after, keep in mind, investigating for several years, would not recognize exculpatory evidence without the help of the defense pointing out what their theory of the case was in advance. And so, therefore, he could not be in violation of any obligation to turn over exculpatory evidence because, he couldn't recognize it when he saw it. In other words, what he was inviting was that for the defense to disclose their theory of the case before he could actually recognize exculpatory evidence, which is ridiculous. Yet that was the sort of thing that was being played. And then when the rules changed so that they had to give us everything, supposedly everything, then they just dumped everything, hundreds of thousands, sometimes even, going close into the millions of pages of documents, where you're trying to figure out where it is, and they would say, well, there might be some exculpatory evidence in there. And then you would find out that there's a warehouse of documents that they haven't turned over, either because some government or some agency doesn't want them to turn them over, and they don't even let the judge know that they have these documents until it becomes necessary for them to show it to the judge, and then the judge would decide, the judges would decide whether to provide it to the defense. But I think we have come a long way. I think those issues will always exist. They're not just going to go away. And I think at the ICC they'll probably be magnified as problems.
Thank you, Michael. Do we have any additional questions? Yes, please.
In my modest opinion, bringing an anonymous witness is strongly against the right of the defense, the right to the defense. And when there is no right to the defense, there is no fair trial. When there is no fair trial, there is no justice. What do you think you could do to fight this rule of anonymous witness and to end it up? Thank you.
Thank you very much. Michael, would you?
I think that at the ICTY they try to reach some sort of a balance on a case-by-case basis, and some judges actually took the time to look at the legitimacy of why this witness had to have a pseudonym and so on and so forth. And sometimes they got it right. But it's a balancing act. I mean, some witnesses do need protection. I mean, on all sides. So we have to respect that. You want witnesses to give evidence. So if you say to the witness, we're not going to give you protection, we're not going to give you this pseudonym, come and appear, the witness doesn't have to come. Of course, they can compel the witness to come and maybe even sanction the witness for not coming, as they have done, or sanction for not testifying. But I think it's a balancing test. You need it, but the question is, has it been abused? And in my opinion, in many occasions, it has been abused, primarily when it's prosecution witnesses. My experience, my personal experience, and I'm not speaking for Mr. Manovich, but my experience has been that on a number of occasions, when we bring in witnesses and we say we want a pseudonym, we want protective measures, the hurdle seems to be very, very high. And in many occasions, we lost witnesses because they weren't going to be given that sort of protection. When it's a prosecution witness, they come in and say, oh, any little excuse. And there were some judges who would summarily say, okay, that's fine, that's enough. And that was part of the problem. And one other issue that might be relevant to this discussion is the fact that in one of my cases, in the Perlich case, the moment we disclosed who our witnesses were, and they were going to come here to The Hague, whether with pseudonym, protective measure, what have you, the state security services in Bosnia and Herzegovina began investigating them. It was very, very clear. And it was a form of intimidation to the point where we raised it with the trial chamber to say, this is what's going on. Our witnesses are being approached by these services, their employers and what have you, and they're scared to come. And of course, what can the trial chamber do? It's the state. You're raising the issue, but what can the trial chamber really do to ensure that your witnesses are not going to be lost because they're being investigated in this intrusive manner for no other reason than to intimidate so that they don't come in and give evidence against the prosecution's truth. That's my personal opinion.
Thank you, Michael. Do we have any additional questions? Yes, please. Peter Haynes.
I think you speak.
I think it works. Well, not.
I'm a bit concerned about the misunderstanding of the term anonymous witness. I think, Michael, your last response might have given a false impression as to practice at the tribunal. In my understanding, an anonymous witness is one whom nobody knows the identity of. And I don't think that was the practice of the tribunal over the majority of its existence. There may have been witnesses who remained anonymous to the public and whose identity was disclosed on a delayed basis to the defence. But beyond Tadic, I don't think there were any anonymous witnesses at the tribunal, and I think that needs to be made clear because the last question and answer was quite confusing. But that wasn't really my main purpose in standing. My main purpose in standing was to address what Gregor said about talking to the press. Like Stephen, I come from a jurisdiction where counsel talking to the press is actually frowned upon. And like Stephen, I've had a very unpleasant experience down the road for the last 3 years, particularly during the last week. The aspect of ethics in talking to the press that I think you need to think about and perhaps needs proper regulation by the ADC and other defence counsel bodies is not the ethics that of bringing yourself into trouble. It's the ethics of talking to the press without express instructions from your client. One of the things that's repeatedly done at the ICC is to use the statements that counsel make to the press against the accused in the trial. And I think the ethics of talking to the press really do require regulation, and you shouldn't do it unless your client tells you that you can do it and unless he approves exactly what you're going to say.
Thank you, Peter. Thank you, Peter, very much.
Well,
Please.
Initially, obviously, I think that it raises a question of difference of tradition because, as you know, two things. First of all, American attorneys can speak to the press. So there is some division, yes, at least between our two traditions. And American attorneys don't take instructions. So we, in the first and second instance, reach a bit of a difficulty. However, having said that, I think that there are some very serious concerns about, as you just pointed to, Peter, the notion that an attorney's statement can be used as an adoptive admission of an accused. And I don't see how precisely is the court entertaining that as valid evidence, or are you referring to this only from the standpoint of outside of the four corners of the tribunal?
No, it will form the basis of submissions by counsel for the prosecution that defence attorneys have made comments on the record and in the press. It will form the basis of written filings and submissions in court that there have been things said by counsel which indicate a contrary position to that which is taken by the defence. And that's why I think the ethics of talking to the press for defence attorneys are very different.
Well, I don't disagree with you there, and my concern would be that any competent counsel that is making a comment to the press, which is inconsistent with the defense and the theory of defense that they've adopted or that they and their client have adopted, it would seem to me that would be incompetence of counsel in the first instance. So it's unfortunate that's occurring. I don't know whether or not you can really regulate that unless you have what I would call a gag order, which is an absolute bar to any of the parties making any comments whatsoever about their views and opinions of a pending matter while the case is being tried. which is oftentimes, I think that oftentimes occurs in the United States, and I know that it occurs in Great Britain. No, I mean, you don't talk about cases as they're going on.
No.
And a lot of that is for the purpose, of course, of protecting the fact finder, which is a jury. But we have professional judges. And as we know, and as we have been told repeatedly over the years, professional judges are not victims of or subject to the same kind of undue influences that jurors or lay people would be subject to, because they can rise above that because they're professional judges. So quite frankly, all of this kind of chatter that occurs in the media should have absolutely no effect whatsoever on the fact finder's determination of the validity of the case being brought in front of them. I say that with a bit of sarcasm, because we all are human, but it is certainly something that has gone into the formula as long as I have been involved in the international process.
Thank you. Yeah, yes, please. This is the last question because we are running behind the schedule. So
It'll be very
please.
short. I'm Colleen Rowan. I'm a counsel at the ICTY, and I just wanted to draw a distinction between counsel who make comments in the press about a case and the particular case that Gregor was referring to, which was counsel who was interviewed by media and was simply expressing his political views. He wasn't referring to a specific case. And that's where I think the danger lies, is that defense lawyers, in the process of perhaps criticizing the tribunal, could be ethically, and in this instance were, even assuming that the statement could be construed as related to the tribunal, can be subject to discipline for expressing political views. That's the danger.
Thank you, Colleen. Okay, if there are no other questions. Yeah. Oh, yeah, I said it was last question, but still, I mean, I would give another try because this was a short question. So, if there are no other questions, I was reminded that I should inform you that for those who have paid for lunch, it will be served on restaurant on the ground floor, and others are advised to visit the reception desk for flyers and information about lunch and snacks. Thank you very much, and we are now taking the lunch break. Thank you.